Welcome to episode 9 of the Oregon Family Law Guy. I am your host, Hansry LaFarst, and as always, we're helping empower Oregonians by helping them learn the ins and outs of Oregon family law. It is Sunday, March 24th, and I know what some of you are thinking right now, and what you're thinking is, hey, Hansry, where have you been for the past couple months? Well, I'll tell you where I've been for the past couple months. I've been practicing. As most of you know, I'm an associate attorney with Mark Kramer and Associates in downtown Portland, and we've got quite a bit of volume in our practice. The majority of our family law cases are in Multnomah. We've got quite a few, obviously, in Clackamas and also Washington County as well, and my caseload these days has taken me not just to the Tri-County area, but also Polk County, Hood River County. And so for the past couple of months, I've been really drilling down, getting into the guts of some of these cases, getting into helping out some of these folks out here. And one of the biggest takeaways that I have over the past couple months is there is a lot of folks that need a lot of help. Just unfortunately, it's not every single time that you can help out some folks that have some of these family law issues, either as an attorney per se, it's very clear. There's just a lot of help that needs to go around, and at least in my humble estimation, Oregon doesn't really make it easy. In terms of the rules, in terms of the way that family law is set up. If you want to get a divorce or you have a child custody matter or a child support matter, it is not easy to represent yourself. As you guys know, you don't need a family law attorney. And I usually say that to all folks that come into my office. If you can do it without hiring an attorney, more power to you, because attorneys are expensive. Getting legal help, it is not easy. It can be just as costly as having a doctor. And unfortunately, you have health insurance for doctors. You don't have health insurance, unfortunately, for attorneys. And with some of the arcane rules that I've seen, just in terms of how difficult it is to file, the paperwork that you need to file in a divorce case, I mean, it's, just to get the case off the ground, let alone, actually finalizing, some case, but just to get it off the ground, whether you're talking the actual petition, some of the confidential information forms, obviously the summons. I mean, it is a lot. It really, really is. So my biggest takeaway from the past couple of months has been that, number one, folks need help. Okay. Number two, Oregon doesn't make it easy to provide that help if you're unrepresented. So to the extent that I can, and to the extent that this podcast can be a resource to some of you folks that are on the fence about hiring an attorney or trying to do it on your own, I want this to be something that you find useful and that could help you navigate, if not the entirety of whatever family law matter that you're experiencing, at least maybe a sliver of it, at least maybe a portion, just to get the case started, just to get it in court, just to get it in front of a judge, so you can have at least some sort of movement on what it is. As I say almost in every single one of these episodes, this is not legal advice, okay? If you're looking for advice, you need to consult with an attorney. If you're looking for something concrete that you're looking to implement in your particular situation, I can't give it to you through this medium because I quite honestly don't know exactly what sort of situation that you're going through, right? Like, every family law case is different. And even though you may be going through a divorce or some sort of child support situation, child custody situation, anything of that nature, the rules are varied, and they're not, a lot of times they're not intuitive. Sometimes they are, but a lot of times they're not. So this is not legal advice, but this is hopefully a helpful guidepost to give you at least a couple of ideas and at least some thoughts as to what you can do to navigate in certain situations and what things you should be on the lookout for. So, with that being said, let's get to the topic of today's episode. And the topic of today's episode is going to be a little bit specific. And I'm going to be speaking directly to those of you who may be post-divorce or post-initial custody determination. And you're in a situation where you and the other parent of the child have agreed to joint custody. And that's what's supposed to be going on. You're supposed to be exercising joint custody. As some of you guys know, custody is not, in fact, who has possession of the child at any given time, even though that's what we like to think of in terms of custody. But here in the state of Oregon, as you know, when we talk about custody, what we're talking about is who has the legal right and the legal authority to make the final decision for the child when it comes to major health decisions, major decisions with respect to the child's education. If you're so religiously inclined, major decisions concerning, the religion of the child, et cetera, et cetera, et cetera. And so joint custody, all that refers to is that in a situation where there's joint custody, both parties have the ability to make that decision. They're supposed to be making it on a sort of unanimous method or unanimous manner, right? Whereas if you have someone that has sole custody, and this is something that we talked about in one of the earlier episodes, sole custody, all that means is that that final authority, that final say when it comes to making decisions for the child, that resides with one of the parents, and that will be the parent who has sole custody. Okay, so let's agree that in this particular situation, you and the other parent have agreed either in the judgment, the dissolution judgment, or the final judgment in a child custody case, that both of you are going to have joint custody, right? And now all of a sudden it's not working. And it could be for any given reason. Maybe you just don't see eye to eye on one particular issue. Maybe the two of you don't see eye to eye on a whole host of different issues. What do you do in that situation? Well, as some of you may know, what you're going to do in that situation is someone's going to have to seek a modification, right? And a modification of the judgment is essentially you or the other parent, or oftentimes both, go back to court, filing the appropriate paperwork, and basically tell the judge, listen, we're going to have to change the original judgment in the child custody case or dissolution judgment. And the reason why we're going to have to change it is because this particular situation or this particular arrangement is no longer working. Well, how do you go about getting a modification? And what are the things that a court looks to when implementing a modification? Let's answer that second question first, right? Well, what the court is going to look to is they're going to look to two things, right? Number one, the court is going to have to determine whether or not there's been a substantial change in circumstances. So in other words, whether or not since the time the court rendered its initial judgment, whether it was a dissolution judgment or whether it was a judgment in a child custody parenting time case, what has changed, what circumstances have changed, and whether or not that's substantial, that's significant enough to warrant the changing of the judgment. So that's going to be step number one, okay, whether or not there's a substantial change in circumstances. Step number two now that the court is going to have to drill down into is what's in the best interest of the child and what change purported will fall within the best interest of the child. And we've talked about what the factors that the court looks to in determining that best interest determination. Those are the factors that are listed under ORS 107.137. Not that I expect any of you to remember that, but just in case, and we'll put it in the show notes just so you have that for a reference. It's about a provision of 6 different factors that the court is going to determine in evaluating, hey, now that we know that there's a substantial change in circumstances, what change is going to best fit, the child or the children in this particular case. So what are those 6 factors? We've been through them, but let's go through them again. The emotional ties between the child and other family members, that's 1. Number 2, the interest of the parties in and attitude toward the child. Number 3, the desirability of continuing an existing relationship. Number 4, the abuse of one parent by the other. Number 5, the preference for the primary caregiver of the child if the caregiver is deemed fit by the court. And number 6, the willingness and ability of each parent to facilitate and encourage a close and continuing relationship between the other parent and the child. So those are the 6 factors that a court is going to be looking at in determining what's in the best interests of the child. So with that background put in place, what's going to happen in a situation where you've got 2 parents who have joint custody, who agreed to joint custody at the time that they entered their initial judgment, and for whatever reason, joint custody just isn't working, and either one of them or both of them goes back to court and they tell the judge, look, judge, there's been a substantial change in circumstances, and it's in the best interest of the child that we change it to give one of us sole custody as opposed to having this joint custody arrangement. Well, here's what we know under the law. Number 1, okay, if you have a joint custody situation and there's been a breakdown in that joint custody situation for any reason, the court is going to look at that as the substantial change in circumstances, okay? So the fact that one of the parents, even though you have another parent that wants to keep that joint custody arrangement, the fact that one parent says, hey, you know what, for whatever reason, this joint custody arrangement is not working for me, well, the court's going to take a look at that, and they're going to say, hey, listen, because of this, because there's a parent that's coming in and saying that this joint custody arrangement doesn't work for them, that in and of itself constitutes the substantial change in circumstances. And you're not necessarily going to need a situation where the child's particular circumstances has changed. It could just simply be one parent just saying, you know what, thank you, but no thank you. And that's going to get them over that first hurdle of proving there's been a substantial change in circumstances. All right. But here's the thing, and here's the real kicker, okay? When it comes to the best interests of the child, okay, and this is a particular situation that I'm dealing with now in one of my cases, you can't just intentionally subvert, okay, or go around the joint custody arrangement and say like, hey, listen, you know what? I don't like this other parent. I don't like the fact that I'm supposed to be having joint custody with them. And I'm going to use this to request that I have sole custody. If that's your only basis, okay, for strolling into court and asking for a modification, that's not going to be good enough to get sole custody. And the reason why we know that is because there's this case in Oregon. It was issued by the Oregon Supreme Court. It's the Ladendorff case, and I'll put the citation in the notes, the case notes or the podcast notes for you to review. There's a case where the Oregon Supreme Court back in 2007, took a look at the factors. They took a look at a situation where mom and dad were not getting along. They had a difference of opinion with respect to where the child was going to do their schooling at and around middle school. Dad went into court and was just like, listen, I want sole custody now. This joint custody is not working. And, oh, by the way, here's a whole bunch of things that mom did that, I don't necessarily agree with. And these are a whole bunch of reasons why, mom is a bad parent and I want sole custody. Well, they both went into court seeking sole custody. And in that particular case, the trial court turns around and gives sole custody to mom. And the Oregon Supreme Court affirms that ruling. And what they say in that case is they take a look at two factors. Number one, they take a look at, that third factor, the idea of the desirability of continuing an existing relationship. And take a look at that and they say, like, listen, in a situation involving dad where he's in essence trying to restrict the child's relationship with mom, they basically said, like, listen, dad, you haven't put forth enough evidence to show us why we would want to restrict the child's relationship with mom and why it's not in the best interest of the child to continue that existing relationship with mom. And they really didn't find as credible a lot of the factors that he was putting forth. So that's one factor that weighed against dad in that situation. The other factor that weighed against dad in the situation was the final factor, the willingness and ability of each parent to facilitate and encourage a close and continued relationship between the other parent and the child. Okay? So if you have a situation where that other parent, you have got one parent who is, essentially having a lot of deep-seated reservation against the one parent, trying to restrict the relationship with that other parent, the court's not going to take too kindly to that. And in this particular case, what they did was they saw that, dad was already going out of his way to try to restrict the relationship that the child had with mom for no apparent reason, or not no apparent reason, but no real good concrete reason, at least from what they could tell. And they said, listen, that's not going to work. They saw that mom was actively trying to work to make sure that the child had a continuing harmonious relationship with the parent. And they said, like, listen, if we have mom have sole custody, we've got a pretty good inkling that mom is going to continue to try to foster that relationship between child and dad. We can't say the same thing if dad had sole custody. So for those reasons and a couple of other different reasons that were mentioned in the case, they turned around and they awarded sole custody to mom. So what are the implications of that case? What's the takeaway that you can have from that case? The takeaway that you can have just in general when you've got two parents who originally had joint custody and now one parent or maybe both parents are trying to seek sole custody is, yes, here in the state of Oregon, if one parent or both parents are saying that joint custody is not working for whatever reason, the bar doesn't necessarily have to be that high. In that particular situation, the court is going to say that there's been a substantial change in circumstances. But tread lightly, okay? Because the court, at least based on case law, the Ladendorff case and subsequent cases after that, they're not going to take too kindly to a parent trying to subvert the relationship between the child and another parent and use that as a basis for obtaining sole custody. So if you've got a parent who is not really engaging in a bona fide co-parenting relationship and who every step of the single way is either sort of secretly or out in the open trying to subvert the relationship and not letting one parent at least participate or co-parent, that's going to be a situation that the courts are going to take a really hard look at and the judge is going to take a really hard look at. So I say all of that to leave you with the idea that, in the case of two parents that are seeking to go from a joint custodial relationship to a sole custodial relationship, outside of, some of the other things, abuse or, some sort of significant problem with the other parent's parenting skills or anything of that nature, you want to think long and hard about modifying from joint custody to sole custody. in a lot of different circumstances, it might be worth it to try to work through some of the problems that you're having with the other parent, either through informal or formal mediation. Because if you have two good parents, loving parents, and parents that don't have problems, and the court even gets an inkling that one parent is not necessarily acting in good faith when it comes to fostering a relationship between the child and the other parent, modification can go both ways, especially if both parents are asking then for sole custody. So that's basically it, and that's essentially it for episode 9 of the Oregon Family Law Guy podcast. As always, what I'm going to leave you with is I want to hear from you guys. I really do. I thank those of you who have viewed some of the videos that we've put out, that have listened to some of these episodes of the podcast, that have visited our Facebook page, that have visited our YouTube page, and have contributed. Sometimes the contributions I get are just like likes, and that's fine. But I really want to hear from some of the circumstances that you guys are going through, and some of the things that you're seeing either in your unique family law situations, or perhaps if you have got a case out in court, what you're seeing. Like I said, and like I said from episode 1, I want this to be driven by what Oregonians think and what Oregonians are experiencing on the front lines. And your contribution, whether it's a comment, your likes, comments about that we're doing a great job, comments about things that we could do a little bit better, those are useful because those allow me and us to really know where to drill down, where to provide information that's absolutely necessary. So, with all that being said, make sure to find us on OregonFamilyLawGuy.com, find our YouTube page, find our Facebook page, like, subscribe, comment, and keep the thoughts going. Looking forward to hearing from you soon.